Hi there. Today's live coaching call, we discussed the legal intersections in real estate. We went over divorce, probate, and foreclosures. So here on our Facebook group, I just want to give you a summary of what today's live coaching call was about. Of course, if you are members, go into our LMS system and you will find this archived in our library for live coaching, where you can review it anytime that you'd like. So let's get started. Navigating legal intersections in real estate. So first and foremost, if you are working in the divorce market, it would be suggested that perhaps you think about becoming a CDLP. There's a lot of things that you can do as a CDLP and have a network of attorneys that you work with that will refer business to you. So take a look at the market that you're in and decide if that might be the right fit for you. But if it's not, there are still important things that you do need to know because many of us as loan originators are often going to be working with divorcing couples, whether we're certified or not. So obviously, for many going through a divorce, that marital home and other pieces of their marital real estate are going to be the largest assets. So what happens to a family home is ultimately going to depend on the facts of each case. So, as a divorce, by definition, it's going to suggest that parties no longer want to live together. But that doesn't necessarily mean that the parties have to separate the ownership of their marital home immediately. You need to take a look at a couple of things. In some cases, one party may need to collect child support and maintenance for a minimum of 6 months to use that support as income to qualify for an equity buyout. So in a case like that, you want to look at the 636 rule. You're going to look at the divorce decree, see what the maintenance is, see what the child support is. You're going to look to make sure that they have received on-time payments that match what's in the stipulation. And you need to ensure that they've received them 6 months in a timely manner, that it matches the divorce stipulation, and that it will be going forward for a minimum of 3 years. So in the case of child support, you need to check the ages of the children to ensure that will be going forward for 3 years. Same with maintenance. Now, if you're working with somebody that may be in the process of going into probate and they want to either buy the house or they want to sell it, there's a few things that you need to know to help advise them. First and foremost, if somebody's purchasing a home and the seller passes away during the purchase, the way that home is vested is going to indicate whether or not that property is going to go into probate. So if the property is held joint tenants in entirety for married couples with the rights of survivorship, then generally speaking, the surviving spouse on that title can still proceed with the mortgage. But should that person be the only one entitled or be in common vested with a sibling or somebody where their inheritance would go to their heirs and not as a right of survivorship, that property will now need to go into probate. And they will need to notify the lender. They have 30 days to inform the mortgage company of the death of the owner. Services will require the death certificate and verification of the inheritance, meaning if the house is in a trust or was passed on to somebody in the will, they're going to need to see those documents. Lenders don't automatically require full payment on the loan, or will they initiate a foreclosure? The client's family is more than welcome to send in payments to keep that loan current and good status while they're going through probate. So depending upon the state that they're in, the inheritor may need to go to probate, they may not. Only one person can be named executor, and if heirs want to assume that mortgage, federal law requires lenders to allow for such transfers. Heirs do have the right to assume an existing mortgage. The servicing company cannot do a due on sale clause because the heirs are protected under the Garn-St. Germain Act, but only one qualified heir can actually assume that mortgage. Under the under the Garn-St. Germain Act, this act allows for the heir, to assume the mortgage. It also protects the estate from the bank foreclosing on the property. However, the estate is responsible to make sure that all those mortgage payments are being made on time. Now, conservatorship is a little bit different. Conservatorship is when the court is appointing somebody as a conservator because the person that owns the property is not of sound mind. So if they want to keep the home under a conservatorship, all mortgage payments and taxes are going to need to be made on time. Refinancing a home that is in a conservatorship is generally unlikely. However, if you petition the court and get permission from the court and make this request with the lender through court documents, there is a possibility to refinance the home. A reverse mortgage on a property that is in conservatorship is the highest possibility of being able to keep that home and keep that person in the home. And as a conservator, if you can show the court your due diligence and show that keeping them in there is the best solution for them, and you get the approval of the courts, then the conservatorship can move forward with either a reverse refinance, or if you have a lender that's willing to do it, the lender can also do a refinance under the conservatorship. But it has to be court approved with the seal of approval from the court, and then you need to find a lender that is willing to do that. So for more information about different things, please feel free to email me, sandy@crimat.com. That's sandy@krimat.com. Please visit our YouTube channel for more helpful information. And if you are new to the industry, 0 to 5 years experience, please visit our website, Crimat, KRIMAT.com, for more information on our Learning Center. Wishing you all a wonderful day.